not related to the incident, but because the existence of them in connection with fact in issue or itself make the fact in issue or the relevant fact is probable, and the improbable existence of that make it probable or improbable. So with that, these two sections we have completed, and now one section left, that is section 10. See, section 10 talk about the conspiracy, and it lay down the rule related to the conspiracy. If you see the Indian Penal Code, chapter 5A, chapter 5A, that have section 120A and section 120B, only two sections, and these were not were in the original the Indian Penal Code. They have been inserted by way of amendment later in 1913, and that has the the some reasons, because at that time there was the national movement, and the freedom fighter, they used to do the things and to the capture those person even before the whole incident happened and make them punishable. This offense of conspiracy has been carved out. So that is the something history. But now it is in the statute book. And if we read section 120A, that talk about the criminal conspiracy when two or more person agree to do or cause to done an illegal act, or second, an act which is not illegal by illegal means. So the act may be illegal, or the act may be the legal, but they have to done it through the illegal means. Now the important thing why I'm reading this IPC provision in the evidence law class is, see the language, what you have to prove when two or more person agree to do. Now how you will move, how you will prove that they agree to do these things. So this is the conspiracy being a matter of interpretation, and it has in the secrecy, it has in the dark, and so it's very difficult to prove that they agrees to do something, because that is not a conduct in the sense that it would be proved by some independent evidences. They may be through any place in the dark, in the secrecy, they have agreed to do that illegal act, and on you have to prove that they have agreed to do that thing, that itself make an punishable offense. What they will do, that would again amount to another the punishable offense. For sake of simplicity, I'm making it simple. दो आदमी हैं, A and B, and they while drinking at the river bank, they decided, and they agree that they will kill, or they will rob, or they will loot a shop. वो एक दुकान को लूटेंगे, ठीक है. अभी क्या हुआ, दुकान नहीं लूटी है, but this agree to do this illegal act in itself is a punishable offense. Now how you will prove it? When the that offense would be committed, that offense that would have been committed by the conspiracy would one offense, and the conspiracy by making these person agree on to do that offense would be the another the penal offense. So that is the thing, and so it's very difficult to prove the conspiracy in the court of law. And in that sense, section 10 is very, very important. If you see and observe the section 10 and the scope of the section 10, because it's so important that in first part of the chapter 2, it is under the second sub topic, you can say. Okay. Now come to the section 10 and read it. I'm reading it. Things said or done by conspirator in reference to common design. Okay. When there is reasonable ground to believe that two or more persons have conspired together to commit an offense or an actionable wrong. So here, offense, and actionable wrong means on which even the civil penalty is imposed. Okay, so civil wrong, actionable wrong here means civil wrong. Anything said, and civil wrong may be like ए और बी दोनों मिल गए, उन्होंने कहा यार ये सी तो बड़ा बदमाश आदमी है और इसका ना मार्केट में बहुत रिस्पेक्ट है, सो वी शुड डिमोलिश हिज इमेज। तो उन्होंने पूरा एक अपना, दोनों इस पे एग्री हो गए, दे मेड दिस प्लान टू डिफेम सी, एंड देन सी फाइल्ड द डिफेमेशन in civil suit, not under section 499 read with 500. Defamation is civil as well as the criminal actionable. So when she filed this defamation suit, it is actionable wrong. Okay, so anything said, done, or written by any one of such person in reference to their common intention after the time when such intention was first entertained by any one of them is relevant fact. I'm leaving last two line. Okay, so what it's saying, if you make it very simple, there are two person A and B. Okay, and they conspire to stole or to steal important items from the ज्वेलरी शॉप ऑफ सी। ठीक है, दोनों ने प्लान बना लिया कि चुपके से जाएंगे और सी के ज्वेलरी शॉप में से जो कीमती कीमती ज्वेलरी है हम चुराएंगे। ओके, नाउ व्हेन बी, बिफोर दिस होल थिंग डन, be all this planning disclosed to another person D. So he said all these things to D. Now whatever he has said would be relevant, and it would be even applicable, it would be even used against A also. So generally if you see that in criminal law there is no vicarious liability when you said, or you say that during this whole plan, if B did any other thing that maybe even A is not aware, but it was done in reference to their common intention. What was the common intention? The common intention was to steal the important jewelry from C, from the shop of C. So both this act of the person, both what he said would be relevant. If in the court of law, when this conspiracy is in the question and C disclose, जी B ने मुझे this D person has disclosed कि D ने मुझे बताया कि उस रात कि A और B दोनों मिलके वहां जाएंगे और वो लूट करेंगे। यहाँ पे क्वेश्चन देखो, A ने नहीं देखा, A को किसी ने नहीं देखा, ए बी के साथ कॉन्स्पिरेसी है ये भी किसी को नहीं पता, लेकिन बी ने जो एक कहा दैट वुड बी ए रिलेवेंट फैक्ट। नाउ इफ यू सी इट फ्रॉम द अदर पर्सपेक्टिव, हाउ द थिंग्स सेड बाय द बी और द एक्ट ही हैड डन लाइक इन फर्दरेंस ऑफ देयर कॉमन इंटेंशन। जब वो दुकान पे जा रहे थे तो गार्ड था एंड बी pick up a stone and throw towards the guard, and guard was injured. So this is an act done in furtherance of their common intention. So three things it make relevant. One, that word said in furtherance of their common intention. The another thing is that act done in furtherance of their common intention, and the third is that word written in furtherance of common intention. कई बार ऐसा होता है A and B दोनों एक दूसरे को प्यार करते हैं, लेकिन इनके पापा श्री या पेरेंट्स नहीं मानते हैं और वो एक एक्सट्रीम स्टेप उठा लेते हैं कि दे विल किल देयर पेरेंट्स। ओके, और मे बी दैट बैड डैडी, वो अपने जो सबसे खतरनाक वाले पापा है जो मानते नहीं, दे विल किल हिम। एंड there is a conversation through the letters, and after that, they hired some person, and this bad daddy is removed from the way of this person. वो किसी से मरवा देते हैं. अब क्वेश्चन ये आता है कि इन दोनों के बीच में क्या एक इस तरह की कॉन्स्पिरेसी थी उसको मारने की, और उसमें उनका लेटर जो है जिसमें लिखा हुआ है कि पापा नहीं मानेंगे, पापा को रास्ते से हटाना पड़ेगा, ये चीजें रिलेवेंट हो जाती है दोनों की कॉन्स्पिरेसी को प्रूव करने के लिए. ओके, इज इट क्लियर? सो दिस इज द स्कोप. नाउ whatever said one, whatever done another thing, and whatever written by any of the conspirator would be relevant. ठीक है, and that would be relevant when the such intention was first entertained, when the first they agree to do or cause to be done any illegal act or any act which is illegal, which is legal by illegal means. After their conspiracy, if anything done, anything said, anything written, by the member of the conspiracy, that can be uh, proved because it is relevant by virtue of the section 10. And this relevant fact is proved or is applicable to prove two things. First, that the members of the conspiracy. So suppose उस आपने बताया कि A and B हम दोनों जाके दुकान में से चोरी करेंगे. So यहाँ पे A is also the member of the conspiracy. इस A की मेंबरशिप प्रूव करने के लिए ये स्टेटमेंट यूज होगी. सेकेंड थिंग इज दैट टू प्रूव दैट देयर वाज ए कॉन्स्पिरेसी, तो कि वो दोनों कॉन्स्पायर होके कॉन्स्पिरेसी है जिसके तहत वो करेंगे. बोथ दीज थिंग्स कैन बी प्रूव्ड. दिस इज रिटन इन द लेटर लाइन. दैट is relevant fact as against each of the person believed to be conspiring, as well as for the purpose of proving the existence of the conspiracy, as for the purpose of showing that any such person was party to it. So anything said, anything done or written in furtherance of the common intention would be a relevant fact, and it can be proved for two things. One is to prove the very existence of the conspiracy, and second is to prove that such person was party to it. Now, if we analyze whole section 10, how the things can be proved, when there is a reasonable ground, there must be some reasonable ground. When there is a reasonable ground, and it does not say that the possibility or the something that beyond the reasonable doubt, reasonable ground. Okay, like A and B, and both are living in a one room. दोनों ने एक मुखर्जी नगर में कमरा लिया हुआ है, और उसके बाद में एक दिन क्या हुआ कि बी ने जो है किसी सी को पत्थर मार दिया. ओके, और उसमें ऐसा रीजनेबल ग्राउंड दिखा रहा है दैट ए इज आल्सो द पार्टी स्पेंट इन दैट offense by way of conspiracy. Actually the act is done by B. Okay, now to prove that A was conspired to injure this person C, कि A भी C को पत्थर मारने की कॉन्स्पिरेसी में शामिल था. एंड दैट इज वेरी डिफिकल्ट, बिकॉज वो अपने कमरे में शाम को बताया कि यार ये सी बड़ा परेशान करता है, एंड वी हैव टू टेक रिवेंज फ्रॉम सी. तो इन्हें कहा कि चलो दोनों ना ऐसा प्लान बनाते हैं कि पत्थर मारते हैं. मैं तुम्हें उधर से इशारा करूंगा या बता दूंगा वो इधर जा रहा है, फोन कर दूंगा, और वो जब उस रास्ते में जाएगा तो आप पत्थर मारना उसके सर पे. ठीक है. नाउ टू प्रूव दैट ए conspired with B to injure the C is very difficult. And so suppose B ने उसी रात जोश में अपने किसी दोस्त को बताया कि वो एक ना लड़का है C, एंड वो बड़ा इरिटेट करता है, लेकिन मैं और मेरा रूम पार्टनर दोनों मिल के और उसको सबक सिखाने का हमने सोचे हैं. अब ये सी जो है, आफ्टर दिस इंसिडेंट हैपन, सी वाज इंजर्ड, पुलिस लॉस द एफआईआर, और उसके बाद में सी जो है ये स्टेटमेंट जो है आपको दे देता है, या सी को आपने बी ने जो है मैसेज किया, और सी वो है वो मैसेज कोर्ट में प्रोड्यूस कर देता है, या सी को लेटर लिखा बी ने, वो प्रोड्यूस कर देता है. नाउ द स्टेटमेंट ऑफ बी, this message of B would be relevant, and this is relevant, it is obvious if you see it, ये relevant तो होगा ही, क्या दिखाने के लिए कि दोनों में कॉन्स्पिरेसी भी थी और ए उसकी मेंबर भी था. भाई आप जब खुद ही कह रहे हो कि हम दोनों मिलके या इस तरह से मिलके उसको सबक सिखाएंगे, उससे रिवेंज लेंगे, so it is obvious that it is relevant, and law also make it legally relevant. So by virtue of section 10 it is legally relevant, but there must be some reasonable the ground, there must be some reasonable ground to believe that these A and B, or you can say in general two or more person have conspired. When there is this reasonable ground, then you can prove the statement of B made to the C through telephonic conversation or the message, etc. My example. Now, if you see from the and analyze section 10. See, as such, there is one word, vicarious liability. So, vicarious liability means the act done by one person, and or you can say the act by the agent, the principal would be liable. So this vicarious liability concept is applicable in civil cases. अब यहाँ पे इसको अप्लाई करो कि मैं vicarious liability क्यों कह रहा हूँ. पत्थर तो मारा बी ने, और हम लाइबल किसको बनाना चाह रहे हैं, ए को भी बनाना चाह रहे हैं. ओके, so this vicarious liability type of the things is applicable only in civil case where the act of the principal, the act of the agent, or you can say the act of the servant is would make his principal or master liable, but it is not applicable in the criminal case. Okay, and this section provide that in prosecution for conspiracy, when concert and connection between conspirator is reasonably believed to exist, whatever said or done or written by each conspirator in reference to their common intention is admissible as evidence against the other. And so section 10 is not something that identity of interest and the community of purpose existing between the party. Section 10 is based on the principle of agency. Like, the partnership, when you will, attend the lecture on the partnership, that partnership is also the mutual agency. So act done by one partner would make another partner liable. Similarly is the conspiracy. In the conspiracy also, the act done by the one person would make the another person liable. So it is the principle of the agency that is applicable in the conspiracy. And when the concert has once proved, the doctrine applied that each partner is an agent for all others, act done by one in pursuance of their common design are admissible against the fellow conspirator. See in the simple language, simply see. कोई आदमी कहता है कि मैं और श्याम दोनों ने एक कॉन्स्पिरेसी की है और हम इस तरह से ये चीजें करेंगे. Yeah, maybe you're right. And this is driven for stressing two things. One, there is a conspiracy, and other, that the other person to whom he is saying he is indicating is also a member of the conspiracy. So if you see simply, there may be very serious issue about it. कि आपने आपके कहने से दूसरा आदमी इसमें applicable हो जाता है. Like in the confession, there is a concept of confession by co-accused. Suppose A को पकड़ा, ए और बी दोनों ट्रायल पे हैं, एंड ए को पकड़ा, ए ने कन्फेशन कर दिया मजिस्ट्रेट के सामने कि मैं और बी बोथ have raped that girl and then murdered that girl. Okay, Now, whether this confession of A would be can be used against the B also or not, that is an issue. And section 30 talk about that issue. Similarly, here, this is something that statement is made after the conspiracy is over or after the act is completed. But the section 10 talk about that the statement or the act or the written things has to be made during the conspiracy. Okay, and so there is serious issue कि the statement of person A is making even criminally liable to the person B, and that's why there is this type of the discussion we are doing. But because it's very difficult to prove the conspiracy, and that's why these things are also taken into the consideration. The another thing is that if the act done by one person we would not make liable, then in individual it would be difficult, because four-person, if suppose they conspire, and when you read the illustration, it would make it clear that it happened that during this our struggle against the freedom or any type of waging war, when the various person are acting in the conspiracy, and so the act of the person would also make the liable to the another person also. Maybe the another person is not aware about that. How is that? I'm reading this illustration that reasonable ground exists for believing that A has joined in a conspiracy to wage war against the government of India. एलिगेशन है कि ए ने गवर्नमेंट ऑफ इंडिया के अगेंस्ट वॉर छेड़ दिया. There is reasonable ground exist. That means the condition of section 10 is satisfied. Now, what would be relevant? What would be the admissible? The fact that B procure arm in Europe. That is, fact means the conduct of B, that he procured arm. Okay, section 10 make three things relevant. Act, first is anything said, an act, and the written statement, you can say. For the purpose of the conspiracy, C collected money in Calcutta for like object. भाई आप जब गवर्नमेंट के खिलाफ वॉर वेज कर रहे हो तो आपको मनी भी जरूरत होगी, आपको आर्म्स की भी जरूरत होगी, आपको पीपल भी चाहिएंगे. So that C collected money. This shows the conduct of C. D persuaded persons to join the conspiracy in Bombay. That is the conduct of D for hiring, for recruiting the persons to wage war against the government of India. E publishes writing advocating the object at Agra. So D is, making this narrative that they are doing something to take the revenge or for the benefit of the society, etc. And the content of letter written by H giving an account of conspiracy. Now, H ने यहाँ पे क्या बवंडर कर दिया कि H ने एक लेटर लिखा, उस लेटर में लिखा है कि ये काम हो रहे हैं. So this is written, and each given account of the conspiracy are each relevant. Now this letter would be relevant and the content of the letter are relevant to show that there was a conspiracy in which B, C, D, E are working. Okay, existence of the conspiracy and to prove that A complicity, that A was also member in it, although he may have been ignorant of all of them, and although the person by whom they were done was stranger to him, and although they may have taken place before he joined the conspiracy or after he left it. So maybe this thing is the other things has been done before he joined the conspiracy, or anything that is even happening after the joining of the this thing. But there is another important thing, that the person who is making the statement must make in furtherance of the common intention, and this shows that when he left the the conspiracy, then his statement would not be relevant by virtue of sections. Don't be confused by this line written in the illustration that joined the conspiracy or after he left it. It is against the person against whom you want to prove that he was the member. The statement is not made by him, the statement is made by some another person. And so the scope of the section 10 is that the statement made, also the anything that is written or the act that is done must be in furtherance of common intention, and that means it has to be done during the existence of the conspiracy. So when the police arrest a person, and after the arrest, if you disclose that in how many how they did it, that would not be relevant by virtue of the section 10, because the catch line, the important phrase is that it must be in furtherance of the common intention. So to disclosing this thing after the conspiracy is completed or after he is arrested, this is not something in furtherance of the common intention. But during that thing, if you said something, during that common intention, if you did something, that act would be relevant. Now, the two important thing is there. One, that there must be a reasonable ground to believe that there was a conspiracy, and second is that there must be a common intention. The common intention is very, very important. One reasonable ground is shown and had ceased to exist is not admissible against the other party. If you see that period of the conspiracy, on the arrest of the accused, as I said, the statement made by the co-conspirator against him would not be admissible. And so the statement made by the person who was arrested would come under the confession part, the confession by the co-accused. And there is the scope of the section 30, how much they would be relevant, how much weightage that confession would have, that statement would have, that statement made by that person, that have the full details of the crime as it is defined in Pakla Narayan Swami, would be treated as confession. So सेक्शन 30 में वो रिलेवेंट होगी, कितना रिलेवेंट होगा, कितना वेट होगा, दैट इज अनदर क्वेश्चन, बट दैट वुड नॉट बी रिलेवेंट अंडर सेक्शन 10, बिकॉज वो कुछ ऐसी स्टेटमेंट या कंडक्ट नहीं है जो कॉमन इंटेंशन के फर्दरेंस में, कॉमन इंटेंशन के रेफरेंस में कही गई हो. द वर्ड यूज हियर इज रेफरेंस. Many times I said even the furtherance. The word in furtherance of the common object is in the English law, but here is in reference. So to make the section 10 is more wider, and in furtherance means something that is specifically related to the that conspiracy that is necessary, and in reference means that refer to that common intention, showing that common intention. So that is the the difference. Here in India, the word used is in reference to the common intention. If you read and see the section 10 again, it is in reference to their common intention. And in the English law, it is in furtherance of the common intention. So there something that is important with their common intention would be relevant. But here, in reference to their common intention is used, and all those things that is with the related to or with the refer to this their common intention would be relevant under this section. Now there are important cases, and without those discussion of those cases, the discussion under section 10 would not be complete. So much emphasis I'm putting on this section, because generally the question is asked from this section, and it is one of the subpart in the first subpart of part 1 of the chapter 2, having so many section 5, 6, 7, 8, 9, 11, and here is only one section. If you see cases, 3 cases are provided on the conspiracy, just to understand the scope, just to understand the true, scope of the section 10, that uh, what is the period of the conspiracy, in which period the statement has to be made that would be relevant, etc. And the first case that I'm taking, before that, I want to give 1 or 2 minutes to you, so that you can ask me that if you have any problem with respect to the interpretation of the section 10, you can have the question, you can have the query with me. Yes, yes, guys, please. Then I will start discussion on the cases. Any any problem with section 10? Any question? Yes, guys, please ask. Vansika Jain. Vansika Jain, can you hear me? Yes, clear. Mr. Abhimanyu, is it clear, section 10, or should I explain it again?
Yes, sir.
Okay, thank you. So now we are proceeding to the, the discussion on the cases that have been provided in our case material. And here is another important thing, and that is how to read a case. Very, very important thing. See, if you see the sources of the law, the president is also the one of the source of law. President means the earlier decisions of the higher courts, like the decision of the Supreme Court and the High Court, because they also make law of the land. They are the final interpreter. And High Court and Supreme Court also decide whether the provision is constitutional or not constitutional. So if you see section 66A of the Information Technology Act 2000 was declared unconstitutional, but latest newspaper reports show that still there are prosecutions, still there are the cases on the section 66A, and the Supreme Court show very concern about it, because they have declared, but still it is in the statute book. So law is not only that the legislature has passed, law is also how the courts have interpreted it, our constitutional court, Supreme Court and high courts. Article 21. Article 21 never has been amended. But if you see the scope of Article 21, it attained such a huge jurisprudence that all the rights that arises by the Article 21 can be written into an unwritten constitution. Okay? So similar is the thing. So that's why we read cases. Because cases, why we read cases? Because cases are important, because they also form the part of law. Okay. Now, most of the cases you will find in our case material are from high courts and the Supreme Court. Now, the 5 things you have to observe, you have to write, and throughout your life, you have to think, or you can say you have to see a case from these 5 perspectives. 5 part होते हैं ना इस तरह से. First is the facts of the case. Facts of the case. Facts are very, very important. And the facts here mean the established fact. Okay? So the facts of the case are important. Suppose the case is decided by the session court, and the session court has convicted person A. He goes in appeal. In high court acquitted person B on the same fact. And then the state went into the appeal into the Supreme Court, and the Supreme Court again convicted, or maybe acquitted. So whatever. Now facts remain unchanged. Facts में तो कोई changes नहीं आएगा. And so it's very important to on the facts. Appraisal of the fact would be different from person to person, from judge to judge. Appraisal, आप उन facts को देखते कैसे हैं? But the facts would remain unchanged. So the facts, the important thing is that first you have to see in every case that what are the facts. Facts means important fact. उसके अलावा बहुत सारी चीजें होंगी, वो आपको नहीं देखना है. And that's why section 136, जब किसी particular मूवी बनती है तो और भी सारी चीजें दिखा देते हैं, फिर वो साड़ी पहन के गई है. These are irrelevant from the some connection problem. So first important thing is facts. Then the important issue is how the case reached to Supreme Court, how the case reached to High Court. If you see the jurisdiction of the Supreme Court, that Supreme Court hear the case in original jurisdiction between the states, between state and center, between state at one side and the center to the different state on the another side, or through the writ jurisdiction, Article 32, or through appellate jurisdiction. So the second is case history, that how the case reached to this forum. If it is High Court judgment, how the case reached to High Court. If it is Supreme Court judgment, how the case reached to Supreme Court. The third thing is issue. Fact हो गया. Important issue क्या है? What is fact in issue? किस चीज को डिसाइड करना है? मेन कंट्रोवर्सी क्या है? When the appeal is filed, maybe the appeal is filed on a particular issue that has to be decided, and that is important. So third thing is issue. The fourth important is argument from both the parties. It is adversarial system. A भी कुछ कहेगा, B भी कुछ कहेगा, और लगेगा कभी कभी कि दोनों की बात सही है, and then judge has to decide the case. So the fourth thing is arguments of the parties, and the fifth one is decision. Decision is not means yes or no. Decision means the reasoning behind the conclusion. Why the court has reached at this decision, to allow the appeal or to dismiss the appeal. Okay, तो लास्ट में तो कोर्ट एक ही लाइन लिखेगा, the appeal is allowed, the appeal is dismissed with cost. cost मतलब खर्चा भी वो देगा जिसने अपील डाली. और सिविल कोर्ट में जाएगा तो वहां पे होगा, आपने सूट डाला कि जी इसने हमारे खेत पे कब्जा कर लिया, और अगर वो आपके हक में फैसला आ गया तो कोर्ट एक ही लाइन बोलेगा, सूट इज डिक्रीड. आपको समझ में नहीं आ गया, एक लाइन बोल दिया सारा जजमेंट का, और फिर उसकी रीजनिंग वगैरह तब आपको जजमेंट मिलेगा वो ऑथेंटिक उसमें लिखा होगा. और डिसमिस्ड दो लाइन बोलेगा. सो दैट dismiss and decreed, appeal allowed, and that is not important. What is the reasoning? Why the court accepted the argument of one party and rejected the argument of another party? So this, ये लिख लो. This will be helpful throughout your life. और कोई बताएगा भी नहीं. The 5 things: facts, case history, issue, arguments, and decision. Okay, so these things. Now the first case that I'm taking is Mirza Akbar versus King Emperor. This is the Privy Council judgment. If you are aware about our constitutional history and history relating to politics, that earlier there used to be the High Court, and then the appeal has to go to the Privy Council. देन फेडरल कोर्ट बनाया उन्होंने 1935 के अंडर, और फिर कॉन्स्टिट्यूशन फ्रेम हुआ, देन वी गॉट द सुप्रीम कोर्ट. उससे पहले कभी एक सुप्रीम कोर्ट भी होता था कलकत्ता में. So Mirza Akbar versus Emperor. This is the decision of the Privy Council, and Privy Council is the highest body at the British time to decide the case, and so it has very much weightage, very much importance, because the controversy is finally settled about the scope of the Section 10 in that particular aspect. Now Lord Writ has wrought this judgment. See, the facts of this case are very simple and very important also, or you can say from the perspective of our deciding the case. Simple. यहाँ पे मिर्जा अकबर हमारे भाई साहब आसिक मिजाज आदमी, and there is lady, and the name of that lady, though it is not important, we can say the appellant in this case. And this lady and Mr. Mirza Akbar has the love affair, and this lady was married. Okay, Meher Taja. So Meher Taja and Mirza Akbar, I'm making it much simpler. Meher Taja and Mirza Akbar were loving each other, and the husband of Meher Taja was in between their love, and so they want to remove that person from their love life. During that period, there was no phone, no WhatsApp, no another type of the electronic communication or telephonic communication. So they used to write letter, and letter was written between Meher Taja and the Mirza Akbar. Mirza Akbar wrote letter to Meher Taja, then Meher Taja wrote letter to the Mirza Akbar. After that, what happened, that the allegation that they hired a person, Ali Asgar. They hired this person, Ali Asgar, and what this Ali Asgar did, that Ali Asgar went to the field where the husband of Meher Taja was working, and by his rifle, he killed the husband of Meher Taja. Then some person who listened the bullet fire, they also gathered. There was, the burning when the bullet is fired from the firearm. There is some smell. So that was smell, and that धुआं सा भी थोड़ा आ रहा था. Now when this person was arrested, Asghar Ali, Mirza Akbar came and said to the police officers that don't arrest him. That only. Now, the case was investigated, and the police found some letters from their houses. And when they read these letters written by Meher Taja and addressed to the Mirza Akbar, from Mirza Akbar to the Meher Taja, they found that there is indication, the reasonable ground was showing that there was a conspiracy to kill the husband of Meher Taja by hiring some person, because killing the person cannot be done by everyone. And so, to prove the content of the letter before the court, and to content of the letter to show that there was a conspiracy, so as to arresting these person, Meher Taja and Mirza Akbar, also in connection with the murder. Otherwise, उन्होंने कैसा conspiracy की, it would be very, very difficult. See how interesting is Section 10. That there was a conspiracy, and to show that both Meher Taja and Mirza Akbar were member of that conspiracy. So just to show that these letters were taken into the consideration. And then the, This person Mirza Akbar, you know that प्यार में तो सब फकीर होते हैं. So there is one provision where through the forma pauperis appeal can be filed. So he filed the special leave from the judgment of the court of the order northwest frontier. At that time, the state like now we have under the Indian constitution were not there. Even when India got independence, our constitution was framed. There used to be four type of state. है तो constitution की बात, but I'm telling you, state A, state B, state C, state D. State A, the state which are British rule. State B, princely state. State C, commissioner. State D, Andaman Nicobar, etc. So at that time, because at that time in Pakistan was also the part of the India, and so the northwest frontier, the judicial commissioner from there, the appeal went to the Privy Council, and it was decided. In this case, you will find two issues. One is issue related to Section 10. Another issue is related to the another thing that may not be applicable or that may not be relevant here. That the case that is decided by the judicial commissioner, in that the two-person under Section 10 of the Northwest Frontier Province Court regulation, there has to be two judges, and if it is not practicable, then one judge can also decide the case. And Mr. One of the judges was on the leave, and so another person, Mr. M.A. Sufi, was appointed. Mr. M.A. Sufi was disqualified, and then this person Mirza Akbar even wanted to get benefit of this, that this has been decided by the improper forum. So on that ground also I has to be given the benefit. And then their lordship has read out this this 1939 the section 7.3 etc of Northwest Frontier Province Court regulation. So that regulation that related to the constitution of the courts. And then they said that because the another judge was not here, and so that's why this person was Mr. M.K. Sufi was disqualified, but he contended on behalf of the appellant, and it was not practicable to constitute a bench without such judge, Mr. M.A. Sufi, who was disqualified, and decided that there is nothing illegal in it, and it is decided by the proper form. So that is the first part of the judgment that you can read it. But that is not important from our discussion on the Section 10. The discussion is whether the content of these letter, that something that we can relate, the something that is applicable and that can be the important for proving the conspiracy. And here the three letter have been interpreted. On the page number 19, you will find there is letter in the handwriting of Miss Meher Taja, then in the handwriting of the appellant Mirza Akbar. And then with these letter, whether the content of these letter that written in reference to their common intention can be used by virtue of the Section 10 as a first is to make a relevant fact, and second, that can be, because it is relevant, it can be used to show the conspiracy and who are the member of this. And then the court has decided the scope of the Section 10 at the length, and said that on the principle that mere the statement made by one conspirator, I'm reading on the page number 21, to the third party or any act not done in pursuance of the conspiracy is not evidence for and against the conspirator. The common intention signify a common intention existing at the time when the thing was said, done, or written by any of the then. And so here that in the letters it was written uh, to this doing something by which the husband of Meher Taja can be removed in the path of their love is important to showing their common intention to remove that person. Another fact that this person Mirza Akbar said to the police officer that don't arrest Asghar Ali is also showing this reasonable ground that there was some conspiracy how this person is relevant, because otherwise how he can why he has said this thing. Now uh, some lines I have to read, that a statement made after the conspiracy was effected. William J. said that it merely related to a conspiracy at that time completed. Coleridge judge said that it did not relate to the furtherance of the common object. The word relied upon in section 10 of the Evidence Act are not in furtherance but in reference to their common intention. These words may have been chosen as having the same significance as the word related used by the William and Coleridge judges, where the evidence is admissible in their lordship judgment on the principle that thing done, written, spoken was something done in carrying out the conspiracy and was receivable as a step in the proof of the conspiracy. The word written or spoken may be a declaration accompanied by an act and indicating the quality of the act as being the act in the course of conspiracy, or the words written or spoken may be in themselves be act done in course of the conspiracy. This being the principle, their lordship think the words of the section 10 must be construed in accordance with it and are not capable of being widely construed so as to include statement made by one conspirator in the absence of the other with reference to the past act done in the actual course of carrying out the conspiracy after it has been completed. So, anything or any statement that made after the conspiracy is completed, after their common intention has been completed, that would not be relevant, but the statement or the act during the conspiracy would be relevant. The common intention is in the past carrying out the conspiracy after the common intention is in the past in their lordship judgment. The word a common intention signify a common intention existing at the time when the things was said, done or written by the one of them. Things said, done or written while the conspiracy was on the foot are relevant as evidence of the common intention. One reasonable ground has been shown to believe in its existence, but it would be a very different matter to hold that any narrative or the statement or the confession made to a third party after the common intention or conspiracy was no longer operating and had ceased to exist is admissible against the other party. There is no common intention of common intention of the conspirator to which the statement have reference in their lordship judgment. Section 10 embodies this principle. This is the construction which has been rightly applied to section 10 in decisions in India. In these cases the distinction was rightly drawn between the communication between conspirator while the conspiracy was going on with reference to the carrying out of the conspiracy and the statement made after the arrest or after the conspiracy has ended by way of description of events then the past. In their lordship judgment, the statement of Miss Meher Taja fall under the latter category and was wrongly admitted. But in truth, the question of law is not really material in this case. The statement so far from admitting the conspiracy with appellant categorically denied, while the woman uh, stated that the appellant had threatened to kill her and her husband if she refused to marry him. She said refuse his advances and stop him to coming the house. Mr. Robert, counsel for respondent, frankly admitted that apart from the legal question, he could not rely on the statement as evidence of the conspiracy or indeed on any other ground. In their lordship judgment, however, admitted the statement which it should be repeated. The judicial commissioner did not attach a very great weight, did not vitiate the proceeding on the material before the court after the statement is excluded. There was evidence sufficient to justify the conviction. The terms of the letter are only consistent with the conspiracy between the prisoner to procure the death of Ali Asgar. The vague suggestion that they relate merely to the scheme to obtain divorce and to raise money for that purpose is clearly untenable. The handwriting of the letter is clearly established. Under these circumstances, the Lordship will follow the precedent established in Pakla Narayan Swami and hold that in case it is impossible to say the proceeding which ended with the conviction resulted into failure of the injustice. So maybe in a few lines you got the confusion that what it making inadmissible. First, the judge, this is, you can mark it, this is the para number, the 1 to 3rd. The third para on the page number 21. And from third para 21 to 22, the whole discussion is very important. First, the judge has described the very scope of the section 10. And it said that when there is reasonable ground to believe that there is a conspiracy, then anything said or done in reference to their common intention would be relevant. And here the common intention means the common intention of the conspirator. And after the incident or the act is completed, then this common intention cease to exist, and after that any statement made, any act done would not be relevant. And so in this case, the letter that has been written between the Mehertaja and this person Mirza Akbar would be relevant, and the statement or the that statement that made by this Motarma Meher Taja, that appellant has threatened to kill her and her husband if she refused to marry him. She said refuse his advances and stop him coming to the house. These would not be admissible because these would show just whatever the things has been completed. And the another ground that the terms of letters are only consistent with the conspiracy to procure the death of Ali Asgar. The vague suggestion that related to the that in the letter there was only the scheme to got divorce, and then those letters there is a conversation about raising the money, etc. So that was with respect to the divorce is not tenable, that cannot be accepted. And so there is no injustice, no illegality for convicting that person, and his conviction is proper. Here I want to make one change, or you can say I think I uh, wrongly said that maybe this Ali Asgar was husband of Meher Taja. Let me check. Yes. Yes, sorry. This Asgar Ali was husband, and the person who killed is Umar Sher. Umar Sher. So please make this correction. Otherwise, it would be be a problem. Uh, the person who killed was, and the person who was hired by this Mirza Akbar and the Meher Taja was Umar Sher, and his husband name was Asghar Ali. I wrongly, told you. Okay, so this is the judgment. Now, from this judgment, and this is very classical judgment. Whenever there is a question on the conspiracy, whenever the question on the section 10, you have to write Mirza Akbar versus King Emperor. And the another judgment also that is in the line, Badri Rai versus State of Bihar. Both this Mirza Akbar and the Badri Rai are very, very important to determine or on the discussion on the scope of the judgment. Only the conversation, only the conduct, only the written statement that is between the that is during the common intention, the common intention existed would be relevant, and anything said, anything written, any act done after this common intention ceased to exist would not be relevant. Okay, so that is the end of this case. Any issue you have, anything that you want to ask from this judgment? Yes, please. 2 minutes I'm giving you. Mr. Anupam Tiwari. Mr. Anupam, can you hear me? Mr. Anupam? Abhimanyu?
Yes, sir.
Anything that you want to ask from this case, Mirza Akbar versus King Emperor?
No, sir, not right now.
Okay. Now the next case on the section 10 is Badri Rai versus State of Bihar. But interesting. If you see the facts that are also very interesting, or it's very important on the section 10 of the Indian Evidence Act. So what happened in this case, that there is this person Badri Rai. बद्री राय की एक स्कूल थी, एक सुनार रहता था, सुनार की दुकान थी, इधर पुलिस स्टेशन था, और पुलिस स्टेशन के बाद में सुनार जी की दुकान थी ज्वेलर की, एंड आफ्टर दैट देयर वाज द रेजिडेंस ऑफ द इंस्पेक्टर. ये लोकेशन, अब सीन को देखो, एक गली जा रही है, इधर पुलिस स्टेशन है, फिर कुछ दूर आगे जाके उसका घर है पुलिस वाले का, इंस्पेक्टर का, और बीच में ज्वेलरी शॉप है, और उसके सामने ही जो है आपकी स्कूल है जिसमें बद्री राय अपने पढ़ाते हैं. अब क्या हुआ, दिस रामजी सुनार जिसकी दुकान है, सुनारी बोलते हैं ना गांव में जिसको, गोल्ड स्मिथ को. द फैक्ट्स आर ऑन द पेज नंबर 2, सॉरी पेज नंबर 23 पैरा 2. इस केस में आप देख सकते हो. सो this Ramji Sunar has this shop in village Nagochia, and it is between the police station and between the residence quarter of the inspector of the police. And Badri runs a school for small boys in that village, 50 yards away from the shop. Now, one unfortunate day, when the police officer was going through the street, he saw there are 5-6 persons who are melting gold and silver. जब सुनार को आप कोई चोरी का सामान बेचते हो तो डायरेक्ट लेगा नहीं, बिकॉज दैट कैन बी द कॉज ऑफ हिज अरेस्ट. तो उसने कहा होगा कि भाई इसको मेल्ट कर दो, पिघला दो, पिघला के दे दो, उसके बाद में कोई सबूत नहीं. सो दिस वाज डन, एंड देन द पुलिस ऑफिसर caught these 6 persons. Then the seizure was also made, that the ornament and the molten silver was the stolen property, and these persons said that they were stolen to the Ramji in the safe which could not be identified as a stolen property. Police officer seized that article, and the Ramji Sunar was also arrested and then he was released on the bail. Then on one day on 24th August, when this पुलिस इंस्पेक्टर वाज गोइंग, रामजी सुनार और उसका परम मित्र बद्री राय, दे इंटरव्यू द पुलिस ऑफिसर एंड सेड दैट केस को बंद कर दो एंड वी विल गिव सम रिवार्ड. ऐसा होता है, कुछ खर्चा पानी दे देंगे. देन ऑन द 30th, सम डेज 31st August, 7 दिन बाद में, बद्री, नाउ दिस इज इंपॉर्टेंट, बद्री वेंट टू पुलिस स्टेशन and in a old newspaper there are currency notes wrapped in old newspaper of value 500. He put before the police officer, पुलिस ऑफिसर के सामने ला, कहा कि साहब ये लो आपकी दान दक्षिणा, और जैसा कि 24th को हमने कहा था वो प्लीज डू दैट थिंग, रामजी भाई का केस खत्म करना है. अब पुलिस ऑफिसर अपने सिंगम टाइप के, उन्होंने केस तो खत्म नहीं किया, नोट भी जब्त कर लिए और उसने बद्री राय को पकड़ लिया. एंड बद्री राय वाज अरेस्टेड first under the section 165A. And then the Ramji Sunar also has to be, put in this whole scene under section 120B, that there was a conspiracy to do the bribe to the police officer, to intervene in the duty of the police officer. Now the question is that only the evidence, the only thing that can be produced was that he said, the Badri said in the police station that this is something that as we talked on 24th August with respect to Ramji Sunar case, you have to hush up. This is the only statement. And now the question is that whether this statement is relevant or not relevant under section 10. Okay. The case through the appeal is reached to the Supreme Court. And before the Supreme Court, so this is the facts, the case decided by the Supreme Court, case history. And the issue was whether the statement made by the Badri in the police station is relevant under section 10 or not. That means it can be proved or not. When it is relevant, then by virtue of section 5 उसका एविडेंस दे सकते हो कि पुलिस ऑफिसर जो और लोग भी वहां पुलिस में थे वो सुने होंगे कि भाई इन्होंने ऐसा कहा. And so through oral evidence that can be proved, and that would be under section 136. Important thing to decide about the conspiracy. Now see the arguments from both the parties. From the Badri side, they said that when he delivered the bribe, that is the end of the conspiracy. The act has been committed. And so this is the statement after the bribe, and so it would not be relevant. From the prosecution side, the argument is that no, the statement and the giving the bribe, the note, is part of the same transaction. And the statement was in reference to the note put on the table in the Thana. And so this is in reference to their common intention of giving the bribe, and it is not after the completion of the act, after the seizing of the their common intention. The statement was in reference to this bribe, that who has given the bribe, why he is giving these note to the the inspector. Now We have discussed at the length what is the scope of the section 10 in the Mirza Akbar versus King Emperor. And now you have to tell me the decision that which argument you will accept, which argument you will reject. Okay? Yes, guys, please be quick. Please, voluntarily you can give the answer. Otherwise, through the name, I will ask you. Yes, Mr. Kunal Raj. Mr. Kunal,
Yes, sir.
can you hear me?
Yes, sir, I can hear you.
The statement made by the Badri that as per our discussion on the 24th August, Ramji have sent these money to you to hush up his case. Whether this statement would come under section 10, would be relevant under section 10, or would it not be, with the reason. Yes, Mr. Kunal, please speak.
So I think it comes under section 10.
कैसे, क्यों, बता दो, कोई नहीं, गलत हो जाएगा तो क्या हो जाएगा, हाई कोर्ट का भी तो जजमेंट ओवर रूल हो जाता है सुप्रीम कोर्ट में. यस कुणाल, क्यों लगता है आपको ऐसा? वंशिका, वंशिका, कैन यू हियर मी? वंशिका, वंशिका जैन. विनय भाई साहब लेफ्ट कर गए मीटिंग को. वंशिका, आशीष, आशीष नेगी, Ashish, please answer this question. Whether this statement would be relevant under section 10 or not. Whether the statement of Badri in the police station would be relevant under section 10 or not. Okay. No, because of the 6, I'm not asking. That would be, your the statement answer is correct that under section 6 also it would be relevant. But that would be relevant only with respect to the Badri Rai. How it would be relevant, how the person, Mr. Ramji Sunar, against Mr. Ramji Sunar, how it would be applicable, that is the question, and that's why the section 10. As the part of res geste, it would be relevant. Okay? Because वो दे रहा है, लेकिन हमें तो रामजी सुनार को भी तो लेना है कि रामजी सुनार भी कॉन्स्पिरेसी में शामिल था रिश्वत देने में. उसके लिए कैसे क्या सबूत करेंगे? विश्वजीत सिंह, मिस्टर विश्वजीत, 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 yes, speak. No? Okay. Udichi Bansal.
Sir, I think the statement made by the appellant will be valid, and Ramji Sonar will also be liable under Section 10. because there was in furtherance in reference of the common intention the statement was made, and he could be made liable on that basis.
Okay, so you mean that the conspiracy was not seized when the statement was made,
Yeah,
because
because there was just an attempt to bribe the police inspector, but they
hmm,
failed in doing that, so
hmm,
the conspiracy was still subsisting.
yes, very good, very good. Well explained. See, as in the Mirza Akbar versus Kim Emperor, it was said that the scope of the section 10 is that the statement made or written or act done when the conspiracy was in the existence, when the common intention was there, would be relevant, and anything said, anything done, anything written after the conspiracy was existed by the person who making this statement would not be relevant. And so, if we apply that case here, the question was not what is the scope. The question was not whether this statement made by the Badri Rai was after the common intention or not. Here, the common intention was to bribe, and that bribe, when he did the bribe, in reference to that bribe, he made this statement. So his statement is with, or you can say, is coupled with the act of bribing. It is not after the bribing, and that's why the Supreme Court held that the statement is relevant under Section 10. Now see, the in the judgment, uh, this the first para of the judgment is about the charges. The second para of the judgment about the facts. Then on the fourth para, there is the issue. And here the issue is whether the statement made by the first appellant Badri on the August 31st, 1953 had been sent by the second appellant with money to be offered by way of bribe by the police officer was admissible against him. That means against the Ramzi. That is in the question. And then on the fifth para, uh, on the fifth para and the sixth para is about the discussion that whether that statement would be relevant or not. I'm reading a few lines. It is from para number 5 on the page number 24 according to my case material. On the para number 5, the last line on the page number 24, from there I'm reading. Section 10 of the Evidence Act has been deliberately enacted in order to make such act and the statement of co-conspirator admissible against the whole body of the conspirator because of the nature of crime. A conspiracy is hatched in secrecy and executed in darkness. Naturally, therefore, it is not feasible for the prosecution to connect each isolated act or the statement of one accused with the act or the statement of the others, unless there is a common bond linking all of them together. Ordinarily, especially in criminal case, one person cannot be made responsible of the act of the statement of the other. That vicarious liability thing we have discussed here. The statement of Badri Rai is making responsible Ramji Sunar. That's why the vicarious liability or wo jo sara discussion kiya na, that's why. So how the section 10 is making this vicarious liability principle applicable in the criminal law, that is explained here. That one person cannot be made responsible for the act or the statement of another. It is only when there is the evidence of concerted action in furtherance of common act. ये केवल उस सिचुएशन में है जहां पे एक कॉमन इंटेंशन है. कॉमन मीन्स that is shared by both the conspirator, both the member of the conspiracy. Concerted action in furtherance of common intention to commit a crime, that the law has introduced this rule of common responsibility on the principle that everyone concerned in a conspiracy is acting as agent rest of them. And here the Badri was acting as the agent of the Ramji, and his statement is showing and by which section 10 is making responsible to the Ramji Sunar of the conduct of the bill. If you see in the simplicity, who was bribing? Badri was bribing. बद्री रिश्वत दे रहा था उसका केस बंद करवाने के लिए. दैट इज अनदर क्वेश्चन कि वो क्यों दे रहा था. दैट वी हैव नॉट कंसर्न, बट वी आर मेकिंग रामजी सुनार इज लाइबल फॉर दैट. So that is by the section 10. Okay, is acting agent of rest of them as soon as the court has reasonable ground to believe that there is an identity of interest or community of purpose between a number of persons, any act done or any statement or declaration made by any one of the conspirator is naturally held to be the act or the statement of other conspirator if act or declaration has any relation to the object of the conspiracy. Otherwise, stray act done in darkness of prosecution of an object has in secrecy may not become intelligible without reference to common purpose running through the chain of act or illegal omission attributable to the individual member of the conspiracy. The rest section para 6 also you can read. And so it was held that there was no substance of the question raised in the appeal and the appeal is accordingly dismissed. That means the preview is Udichi and all of you are of the opinion it is within the preview of the section 10 and it cannot be discarded. So from Mirza Akbar to the Badri Rai, the scope of the section 10 has been very much explained. If we again see the section 10, that first there must be the reasonable ground that there was a conspiracy. When that reasonable ground is established, then the statement by any of the conspirator, statement, act or written thing can be proved if that statement or that act or that written statement is in furtherance of the common intention. And in reference word is used, but generally it is said as in furtherance also. In the English law it is in furtherance, here it is in reference to their common intention. And here in reference to the common intention means that common intention has to be existed. When the common intention is ceased to exist, after that this statement or the act or the written things would not be relevant by section 10. And so the statement or the act or the written thing made during the conspiracy is in the existence would be applicable after the arrest, after the offense was completed, the conspiracy is completed, there is the end of their common intention, and then the statement whatever he has to be made would not be relevant. The statement made by this lady after the conspiracy that he has to there was the threat by Mr. Mirza Akbar that he will kill his husband if he would refuse the proposal of the marriage, etc., was rejected. And the content of the letter, the things that it was about the raising the money and not to hire a person for killing, raising the money and hire a person who can get divorce of that was rejected, and the conviction was held to be legal. Similarly, in the Badri Rai, the conviction was held to be legal and the appeal was dismissed because the statement of the Badri Rais was not after the existence of their common intention or ceasing to exist their common intention. Rather, it was in reference to the money that he has put to bribe the person. And so Ramji Shunar was also responsible because section 10 would apply and this statement would be relevant, and that making section Ramji Shunar as the member of this conspiracy, because section 10 says that this statement would be relevant and this statement would be applicable for proving two things, that there was a conspiracy and that the person against whom the person who is in this conversation was also the member in the conspiracy, or you can say the members of the conspiracy and the existence of the conspiracy. These two things has to be. Now there is another case in our case material, the third case on this conspiracy, and this was about the blast that happened, that done in the Kolkata city, and the Tada Act was also, imposed. Mohammed Khalid versus State of West Bengal. See, the facts are very, very simple. That at one unfortunate, day, uh, some blast were happened in the city. Uh, the bomb were exploded, and that caused the demolition of two buildings and killing of several persons. I'm not going in that much detail because that would be uh, uh, make our discussion more lengthy, and it would be uh, you know not proper because time is very less. Okay, so the accused the accused, they saying that section 10 was wrongly used, and the things that was said was outside the scope of the text, section 10. Throughout the this case, you will find certain things that maybe one is that when the accused is convicted under 2 3 sections, like murder and rape, and or maybe murder and rape, or with the 2 person, then section 34 is also covered. Then if 5 person with unlawful assembly, 147, 149, etc. And in that case, on each individual section punishment is done. And so suppose the punishment is for the rape, it is life imprisonment. For the murder, it is also life imprisonment. So the question comes ki ye dono life imprisonment hai, how it will done. So generally in the CRPC you will find that the punishment will go concurrently मतलब साथ की साथ चलती है. सो सपोज अगर एक ऑफेंस में आपको 10 साल की सजा है, दूसरे में 5 साल की सजा है, तीसरे में 3 साल की सजा है, एंड द वर्ड रिटन इन द द जजमेंट इज दैट द पनिशमेंट विल रन कंकरेंटली. सो वो सारी साथ चलेंगी, और मैक्सिमम आपको 10 साल तक ही जेल होना हो. उसके बाद में भी जेल में जो है आपके कंडक्ट वगैरह को देख के देर आर मैनी द स्कीम दैट बाय विच इट वाज रिलीज एक्सेट्रा. अभी कोविड में भी काफ़ी लोगों को रिलीज किया है. ओके, so that thing. And then the another is consecutively, one after the another. So generally it is concurrently unless it is written as consecutively. But judiciary या तो concurrently लिखेगा या consecutively लिखेगा. Consecutively मतलब one after one. Suppose there is a two, the act done is fall under 2 section. So आपका उसमें 5 5 साल की सजा है, and it is written that consecutively. So एक के बाद में दूसरी, पहले 5 साल फिर 5 साल, तो टोटल 10 साल. Okay. Now there is 2 3 things that one is that after the arrest of these person, uh, you know the confession was made, and that after that confession, when it went to the police officer, that sorry before the court in the trial, the person retracted from the confession. उसने कहा नहीं नहीं मैंने ऐसा कोई confession नहीं किया, मैंने कोई retracted confession. So when the one of the accused make the confession against the another co-accused, whether how much of the confession can be used against these co-accused, and whether this confession can be the basis. So that is the one question in this particular case. Another is the scope of the section 10, uh, that the things said during the the period when the conspiracy was there, because this the process of blasting, the making of the bomb is not the act of the 1 person, 2 3 person maybe take that material, then one is making them, etc etc. So what happened, if you see the background, that in 1992 this blast was done in the Mumbai, and so in the city of Calcutta, some people they were also making the bomb, and there the defense of these accusers, that because there was attack on the Muslim community, so they are making these bomb in the self defense, and that accidentally blasted that thing. So the terrorist act, the TADA, that is infamous act TADA, terrorist and disruptive act was also imposed, and the sanction was given by the government. So these person approached to the court that that yes, maybe we are liable under the different act, like the, when we use pistol vagela, it is under arms act. When we use explosive, it is under explosive act. So it is under explosive act. So explosive act, killing the person, etc., for that maybe we are not, we are liable. But we are, our activity was not terrorist activity, and our case does not fall under TADA. That was their main argument in this case against that sanction to prosecute the case under the TADA act. Now see the question, that the first important thing is the confession of the person. So that shows that they has to terrorize, they has to take the revenge, etc. But later on that was retracted. Another was the section 10. These two things are there. Now see with the and the famous lawyer KTS Tulsi, senior counsel, was appeared for the prosecution side. Now the with respect to the confession, or you can say confession by the co-accused, I want to give 2-3 minutes. The Kashmira Singh versus State of MP. This is very, very important case, and when you will appear for the entrance examination of LLM, or maybe for any judicial service or other competition examination, it can be asked that which the Kashmira case is related to which section. Kashmira Singh versus State of MP, AR 1952, Supreme Court 159, the confession by the co-accused, and Haricharan Kumari versus Haricharan Kurmi versus State of Bihar, the AIR 1964, Supreme Court. This is another case. On the page number 32 and 33, you will find this type of the discussion, that how much of the confession of the co-accused is important, and can it be the basis of the conviction. So the Supreme Court has said, and it is clear, that the confession of the co-accused is obviously, it is the evidence, but it is a very weak type of the evidence, and it is much weaker type of evidence than the evidence of the approver, Sarkari Kawan. And so when there is other facts that suggesting the confession of the co-accused may be used as supporting evidence for the conviction. Otherwise, in itself, the confession of the co-accused cannot be the basis of the conviction. Now, that is something that I have told you, because during this discussion, you will also find this type of the thing. The main issue is about the section 10. And on that, you will find the discussion on the page number 34 and 35 about the scope of the section 10. It says that the first condition, which is almost opening lock to the provision, is existence of reasonable ground to believe. That is, the conspirator have conspired together. This condition will be satisfied even when there is some prima facie evidence. Without prima facie evidence, the statement made, conduct done, or the written statement would not be acceptable, because if we make them acceptable, they can be used against the another person also, that there was a conspiracy and this person was also the part of that conspiracy. As if aforesaid preliminary condition is fulfilled, I'm reading on the para number 34 of this Muhammad Khalid versus State of West Bengal, that anything said by one of the conspirators became substantive evidence against the other, provided that should have been the statement in reference to their common intention. Under the corresponding provision in English law, the expression used is in furtherance of the common object. No doubt, the words in reference to the common intention are wider than the word used in the English law. But the contention that any statement of conspirator, whatever be the extent of time, would gain admissibility under section 10 if it was made in reference to common intention is too broad a proposition for acceptance. We cannot overlook that The basic principle which underlies the section 10 of the Evidence Act is the theory of agency. Every conspirator is the agent, uh, is an agent of his associate in carrying out the project of the conspiracy. Section 10, which is an exception to the general rule, while permitting the statement made by conspirator to be admissible as against the another conspirator, restrict it to the statement made during the conspiracy during the period when the agency was subsisted. When the agency was subsisted means when the conspiracy or when the common intention has not been reached. Once it has shown that the person became snapped out of the conspiracy, that means he left the conspiracy, any statement made subsequent thereto cannot be used against the conspirator under section 10. Way back in 1940, then the earlier judgment of the Mirza Akbar and versus King Emperor has been discussed. And then intention on the page number 37, intention is volition of mind immediately preceding the act, while the object is the end to which effect is directed, the things aimed at, and that which one endured to attain and carry on. Then on the para number 38, that in Bhagwan Shavrup case, it was observed that the expression in reference to their common intention is wider than the word in furtherance to the common intention, and is very comprehensive, and it appeared to have been designed designately used to give it wider scope than the word in furtherance of in English law. But once the common intention ceased to exist, any statement made by the former conspirator thereafter cannot be regarded as one made in reference to the common intention, and therefore the post-arrest statement made to the police officer was held to be the beyond the purview of the section 10. So any statement that is made by the police, this accused after the arrest, was held to be not relevant under the section 10. And similar view was expressed also by this court in the Nalini case. So the court has refused to take the statement made by some of the accused about how the conspiracy, how they had all did all these things, as to use against the other person to take those person in the trial and to prove the conspiracy and to prove that those person were also the member of this conspiracy. There is another the issue add in, and that is about the very important in the courts you will find when you will become judge or the advocate. See, under section 137, first has to be done 137 read with section 138 of the Indian Evidence Act. पहले examination in chief होगा, then cross examination, then re-examination. And what happened that in this case, the court said that court has observed that there was many adjournment after the examination. So after the examination, cross examination has not been done. And so the court said that there has not to be deferred cross examination. In the court also, I have observed that when examination is chief done, the cross examination has to be done. कई बार ऐसी होती है कि किसी लॉयर का फादर मर गया, उस दिन छुट्टी की हुई है, तो भी एग्जामिनेशन होगा तो क्रॉस एग्जामिनेशन होगा, वट एवर बी द सिचुएशन. बट इन सम unavoidable situation that can be done, but as far as it is practicable, cross examination cannot be deferred. So this latter part of the judgment, section 46, 47, 48, etc. On the page number 37 would be about that adjournment. Two cases. One is the state of UP versus Sambhunath, and NG Dastane versus Srikant S. Sivde. On the page number 37 last you will find. And from these two cases, you can read these paras also. But here it is that when a person come to give the testimony, to depose his evidence, he has other works also, but he has, because he has no option, because the witness can be forced to come and give the testimony, and that does not mean कि उसको कोई काम नहीं होता. And so to giving the adjourning the proceeding and deferring the cross examination is not proper. This is the professional misconduct also. And uh, yes, in the practice also I have observed that generally judges do not defer the cross examination, so that part also we can discuss. So in the Mohammed Khalid versus State of West Bengal, basically it deal with three things. uh, One is about the confession by the co-accused, another is about scope of the section 10, that is most important for us, and the third one is about the deferred uh, cross examination or adjournment after adjournment, and witness has to come again and again, again and again, that thing. So with that, we have discussed section 10 and the judgment that related to section 10. Whenever the question is asked, first you have to discuss the section 10, then the scope of this thing in reference to the common intention, then you have to discuss these cases also. The Mirza Akbar versus King Emperor, the Privy Council judgment of 1940, Badri Rai, and the third judgment is Muhammad Khalid versus State of West Bengal. So with this, today's discussion is over. Now, if you have any question with respect to these cases, with respect to the section 10, or any other question that you want to ask, you can ask me. I'm giving 1 minute, and after that, I will leave the meeting. Yes, guys. Any question, anything that you want to share? Feel free. कुछ भी पूछना हो